The first thing I did, and the first thing any lawyer would do investigating accusations of illegal conduct, is to talk to the individuals who are making the accusations. Now, if you look at the report that the former Attorney General of Massachusetts put out, you will notice that he very carefully avoided talking to any of the ex-employees, ex-directors who have made the accusations of wrongdoing, who have exposed the violations of the law. He only talked to persons who are currently affiliated with or employed by Acorn. In fact, at the same time that Acorn is claiming that it did this great investigation and was cleaning up its operations, it is suing other whistleblowers, like, for example, Anita Moncrief, who was a former Acorn employee who blew the whistle on some of the things they were doing, and they are suing James O'Keefe and Hannah Giles, who, as you know, exposed the sordidness and illegality of Acorn's operations with their undercover videos. That doesn't show much remorse by Acorn or a real intent to clean up the way they do business. And by the way, who is the former Attorney General of Massachusetts? Well, he's the former District Attorney of Middlesex County, Massachusetts, who you may recall perpetrated one of the worst cases of prosecutorial abuse in the history of the state of Massachusetts, probably the worst miscarriage of justice in that state since the Salem witch trials. He obtained the conviction of Gerald Amirault and other employees of the Fells Acre Daycare Center in Malden, Massachusetts, based on phony, hysterical charges manufactured through false testimony, quote, dragged from preschoolers, as the Wall Street Journal put it. He then rode that case into the Attorney General's office in Massachusetts. Let me talk about the Gershon decision very quickly. Congress cut off funding to Acorn, federal funding, through the continuing resolutions that are right now keeping the government going. Acorn sued, claiming that this cutoff of federal funding was an unconstitutional bill of attainder under the Constitution. Again, without boring you on old constitutional law, bill of attainder, is this provision that basically says that Congress cannot act like the judiciary. They can't pass a bill and find somebody guilty and decide their punishment. That's up to the judiciary. But in the entire history of the United States, the Supreme Court's only found a bill passed by Congress to be a bill of attainder 5 times in our entire history. And Ed Whalen of National Review, where I also sometimes write, called this decision by the judge a nutty decision, and frankly, I have to agree. I mean, if you read it, it reads like something that a first-year law student would write. She starts off very well. She says that invalidating a federal law can be approached only with the utmost gravity, and that such provisions enjoy a high presumption of legitimacy. But then she basically overrides what she just said and finds the law unconstitutional. She misapplies the test the Supreme Court has developed for this, and the case shows an unbelievable ignorance of the way our government works and the way our Constitution works. I'm going to just give you an example. She justifies her decision because she says that Congress did not, quote, order any agency of government to conduct an investigation of Acorn's wrongdoing. I'm sorry, but Congress doesn't have the ability as the legislative branch to order agencies in the executive branch, the FBI and the Justice Department, to do an investigation. We have a separation of powers, and the executive branch reports to the president. The only thing Congress can do if they don't like what's being done in the executive branch is they can have oversight hearings, or they can refuse appropriations. But this judge is under this mistaken belief that Congress was not justified in cutting off discretionary federal funding because it didn't order the Justice Department to conduct an investigation, which shows a profound ignorance of the Constitution. She also faults the congressional cutoff because she said that Congress did not initiate a congressional investigation of Acorn before doing so. Now, I certainly agree they ought to be doing a congressional investigation, but if Congress had to hold hearings before they decided to spend money, I mean, that is just not a constitutional requirement. They don't have to do that. She also faulted Congress because they didn't follow the regulations that have been issued by some agencies in the federal branch, in the executive branch, which provide for the cutoff of funding to federal contractors, who have done something wrong. So she basically was saying that Congress has to comply with regulations issued by the executive branch, which is, I mean, any lawyer would tell you that's just crazy. So it's a nutty decision, as Ed Whalen says, and hopefully the Justice Department will appeal it and continue to fight the case. I'm not positive that's going to happen because, if you see what's happened in the Justice Department for the past year, there have been politics behind so many of the decisions that have been made on whether to prosecute and whether not to prosecute, such as the case all of you probably read about when the department dropped a case it had already won by default against the New Black Panther Party in Philadelphia for engaging in some of the worst voter intimidation the department had seen in the last 3 decades. What needs to happen is there should be a federal investigation going on by the FBI. Only the FBI and the Justice Department have the ability to investigate a nationwide organization, to do what needs to be done to get to the bottom of all that has happened. And I think everyone in this room probably knows that federal investigations have been done of a lot of different individuals and other organizations based on a lot less evidence than this. And if there were 5 undercover videos showing a national mortgage broker company providing advice in their offices on how to commit mortgage fraud and tax fraud in applying for mortgages, there's no question that the Justice Department would have opened up an investigation as soon as those videos came out, and yet that hasn't happened. Thanks.
Thank you very much. And next I'll turn it over to Marcel Reed, and I just want to reemphasize how lucky we are to have you participating, Ms. Reed, with our panel. She is the definition of a community organizer. And so she's seen ACORN and the way community organizations are supposed to operate up close based on her prior experience. And for her troubles of taking on ACORN and criticizing her former colleagues, she's been personally vilified and attacked. So she comes forward and takes on this issue at great personal cost and courage. So we really appreciate that. We do this as a matter of course. But we understand your personal stake in this as well, and we appreciate it. So that being said, please, Ms. Reed, I turn it over to you.
Hello, my name is Marcel Reed, and I am currently in exile, the chair of ACORN in Washington, D.C. and Northern Virginia. I joined ACORN in 1999 after reading a book, and in the back of that book, ACORN was listed as a resource for purchasing a home. That book was written by Dr. Laura Schlesinger. I noticed that I talk about it quite often, but I don't see anyone raising their hand to admit they did it. Where I lived at in Northern Virginia, which is Mount Vernon, ACORN did not recruit, which is something I didn't know at the time. ACORN recruits specifically by zip code, and there are specific formulations for how they recruit. I lived in zip 22309, and they don't recruit there. So I was attracted to ACORN via the mission. I had lived on military bases, and at that time was living across the street from Fort Belvoir. So I'm very familiar with missions and what they require. And so for me, transferring all the time as a military wife, I had seen the same instance of poverty over and over and over and over and over again. And I had seen the same offhanded responses to it. Pray more, work more, and don't whine.